Good afternoon, everyone. Welcome to our April 17th webinar on what does the law require that your association is not doing. My name is Elena Gilbert. I will be presenting today. And before we get started, as always, let's go through a few housekeeping items. So, in front of you, if you have not done this before, the bulk of your screen should be the slideshow. So you should be looking at this dude pointing his finger right now. And to the left on the side is a little video of me. Hello, it is me. And on your right top hand corner, there should be a little icon that says private chat. That is the icon you click on and you type into with any of your questions as we go through the webinar. I do save questions for the end just to make sure we have enough time to go through all the materials, and then we cover as many questions as we can at the end. If you are having any problems with your audio or your video, there's also a little button down at the bottom that says having trouble with your audio or video, question mark. You will click on that and it'll take you through a few steps, and typically that will take care of the situation. But if not, you can reach out to Jessa Ledesma, who is the education coordinator, and she can assist you with your issues. And you can call her at her direct office line. That's 303-991-2086. You can also email Jessa at jledesma@altitude.law. So anyway, Jess is the person who can help you. I cannot help you from here with respect to any technical issues or whatnot. This class today is eligible for 1 CMCA credit for those of you who need it, and it will be automatically emailed to you once we get the verification that you have attended the entire class, or that you have had your computer on and that you've actually been paying attention the entire class. If you don't see an email pop up from us with that credit by, I would say, Thursday afternoon, please reach out to Jessa. You can use the same contact info I just gave you, so she can make sure and get you another certificate sent out. And last but not least, at the end of the presentation, for those of you who have done this, as you already know, there is a survey that pops up that just helps us improve future presentations. Most of it is multiple choice, and then there's at the end there's if you want to add additional comments. If you have time and the willingness, we always appreciate feedback. It's the only way we can make these things better, and we do look at all the feedback that we get. So please be honest, and you know, it just helps us improve. So without further ado, let us get started. Okay, so in general, I always have to start with the in general. Where do requirements come from? Well, they come from all sorts of places, right? They come from statutes, state statutes like Iowa and the Nonprofit Act. They come from federal statutes. They come from our governing documents. They even come from our policies and rules and things like that. So there's all sorts of sources out there with respect to requirements that associations have to follow. But for the purpose of today's presentation, what I really want to focus on is Iowa, Nonprofit Act, and one little thing with respect to the Condominium Act. So that's really for today's class what I will be focusing on. And obviously, as I said, you can have requirements from other places, but I want to focus on a few that perhaps not everyone is aware of, or not everyone is doing correctly, and these things tend to confuse people. So the first thing I want to talk to you about, this is all going to be under Kiowa, is the public disclosure requirement. It is slightly, I think, misnamed because when you hear the word disclosure, you think, oh, I have to proactively do something and put something out there and give people things. And that's not really exactly how this provision is written. So it's really a when, what, and how, right? So let's first talk about the when. When do you have to do or make these disclosures? There are 3 instances when you have to do that. One is 90 days after you transition from developer control. So if you are on a board or you're managing a community that's transitioned already, you don't have to worry about this first when, okay? But if you're on a developer controlled community board or you're managing one, please make sure that within 90 days of that transition, which is when you hold the meeting to elect the homeowner control board, that you comply with this requirement. And we'll talk about how to do that. Next one, when? Within 90 days after the end of every fiscal year. Okay, so a lot of associations are in a calendar fiscal year, and if you are one of those, that means by the end of March, you have to do this. If you're in a different fiscal year, it's 3 months or 90 days after you finish that fiscal year. Last one is within 90 days of any change to the disclosed information. So to the extent there is a change to any of the things we're about to talk about, you've got 90 days to update the disclosures. So those are the whens. Now let's talk about the whats, because that's really, I think, important, right? What are we supposed to be disclosing here? There's a few things. So there's the name of the association, which you would hope everyone already knows the name of their association, but you might be surprised. And then there's the name of the common interest community. Usually it's one and the same. Sometimes they're different. The name of the common interest community is the legal name of the association. It's what the Articles of Incorporation state. Oftentimes, associations go by different versions. Like you could be ABC Condominium Association, Inc., and you really just go by ABC Association or ABC Condominiums or something like that. So you could have variances of the name of the association and the technical name of the association. You have to provide the management company. So what is that? What the identity of the management company, if you have one, as well as the physical address of the management company and a phone number associated with that management company. If you don't have the management company, you have to provide then a physical address and a phone number for the association that is not the management company, which means it's going to be a board member or something like that. Probably a board member. I don't know how else you would do it. Next, you need the date of recording and the recording information for your covenants. That's your declaration, your CC&Rs, same thing. And you basically need to either put the reception number or the book and page number and the date it was recorded. That is a stamp that's on the first page of the declaration that you should have a copy of, and that information is right there in that stamp. Again, this is a document owners should have in their possession, so it's not anything earth-shattering that you're providing in this case. Next, the date when the fiscal year commences. So again, if you're in a calendar fiscal year, January 1st would be that day. If you're not, then whatever date you use, that's what you would disclose. Your current budget. So for this current fiscal year, here's our budget. List of assessments by unit type. Okay, so some associations have, it's the same assessment for everyone, and that's what you would put if that's all it is. Some associations will base their assessments on square footage or the number of bedrooms. Whatever category you utilize, you would need to show all those different levels of assessments. Financial statements, including the amount in reserves. So that would essentially be, I think, your bank statements, perhaps. And again, something that shows how much you have in reserves currently. Most recent financial audit or review, if you have one. A list of insurance policies. So you don't actually have to provide the full insurance policy. That is a big, big document, and it's usually a few hundred pages, and that's not what's required. You can typically provide the requisite information by having a copy of the declarations page for your insurance policies, and that's that initial summary page or two that you get. That's kind of the first thing you see, because under Kiowa, what you really have to disclose are the names of the insured, the policy limits, the deductibles, if you have any additional insureds, and also when the policy expires. And that can all be found on those summary pages, the declarations pages. You need to have copies of your bylaws, your articles of incorporation, your rules, your good governance policies, all those typical documents that you probably already do have copies of on your website. And the last but not least thing is minutes of board meetings for the preceding year. Okay. Now, that doesn't mean you should be destroying your minutes from more than a year ago. It just means these are the only minutes you have to disclose. Okay. Which leads us to the next question, which is how on earth do we disclose all of this? And this is really where we look at the fact that we don't actually have to affirmatively send things. Well, we sort of do, but we don't. There's three options when it comes to disclosures, and you only have to pick one, okay? Most associations pick the one that says you can post all of this on your website. Easy peasy, it's on the website. You can label that page as your annual disclosure page, or you can just have it in different categories, but you can post it on your website. The caveat though, and this is the thing most folks are not aware of, is you've got to provide your owners with notice of the web address where they can find these documents. Now, the notice can be provided either via email if you have everyone's email address, or you got to send it via snail mail, like on a postcard, or however you want to do it. But that's something you have to do in addition to posting this information. Okay. If you don't want to post it on your website, you can actually have a binder with physical copies of all these documents, and they have to be at the principal place of business. So what's the principal place of business? Generally, well, you have to look at the Secretary of State website. Typically, it's the management company is in there as the principal place of business. If you don't have a management company, then it's typically one of the board members' homes. But you can choose to have all this information in this physical binder that you keep at your principal place of business, which means homeowners can then say, I want to see all these disclosures, and you need to let them come and take a look at the physical binder and look at all the things in there. Finally, you have your last option, which is you can personally deliver physical copies of all this stuff to each owner. I suspect there are very, very few associations that do it this way. Maybe if you have a very small association and you know everybody, you do it that way. But ultimately, I think we're really looking at making sure you have everything on your website and sending out that annual reminder of here is the website address where you can find all the disclosures. All right, enough of that. You guys probably are jotting down notes. So let's talk about owner education. Another, I think, requirement that gets overlooked by associations and also misunderstood. So owner education is something Kiowa requires, and this is for all associations. It doesn't matter when you were created. Public disclosures is also all associations, regardless of when you were created. So owner education, you have to provide to your owners, to your members, at least annually. You cannot charge for this education, and it has to pertain to essentially almost anything dealing with, you know, running the association, governing the association, the rights, responsibilities, anything really association related is fair game for this education. The next question I typically get is, well, how do we do this? What do we have to do to educate our owners? Well, the good news is kind of pretty much silent on how you do it, which means boards have a lot of leeway and a lot of discretion in determining what they want to do for the education piece. So things I have seen different associations do, they have an industry professional, like they have the attorney, or they have their insurance professional, or, you know, whoever else, a banker, come to the annual meeting, attend the annual meeting and answer questions or provide a brief presentation on something related to this. They publish a newsletter that they pull off, for example, their law firm's website or something from the insurance or what other professional, and they publish that as part of their newsletter once a year. You really have a lot of discretion here, and you can be very creative. Here's really what you need to pay attention to, though, and that is making sure whatever you do for education, that you designate it as the education component. So if you're publishing something in your newsletter, an article, make sure you have bolded letters that say annual education for owners. Here's the article. If you're having a presentation at the annual meeting where somebody comes and talks about things, make sure your agenda says annual owner education component piece, whatever. You just want to make sure it's designated as the education piece. Why? Because Kiowa is so broad about how we do it and when we do it, that you don't want to have owners challenging you, saying that, hey, you never did the education piece. And you're going to say, well, yeah, we printed this article. Well, you print an article every month. How is that the education piece? You just want to make it very clear and designate what it is that's the education component that you're doing on an annual basis. All right, so don't forget. Access to common elements. So this is both a you can't and a you have to at the same time. So we had some legislation a couple years ago, if you recall, that basically stated that associations cannot close off access to common elements except for during maintenance, repair, replacement, or modification. Okay? And you can only close it off for the time that is necessary to perform the work and for safety issues. That is the only time you can close it off. And on top of that, here's what you have to do. If you're closing it off for more than 72 hours, you got to do these things. You have to have notice that goes to your homeowners. It can be via email, it can be via snail mail, but you have to send them notice that they are that you are closing off the common element. Which common element? We're closing off pool, we're closing off this part of the street, whatever it is. You also have to indicate the reason it's being closed off and the estimated time until reopening. We are closing off the south side stairs to the building because we need to install new stairs. We anticipate the stairs will reopen in 2 to 3 weeks. You have to provide a phone or email address where owners can reach out if they have questions. And then you actually have to post a physical notice at that location where you're closing the property off. So the physical notice must also provide the same information: why it's being closed off, when it's reopening, and who you can contact with questions. Okay. Why do we have this law? What is it intended to prevent? It is intended to prevent situations where associations say, well, you know, we have a pool, but it's going to cost a lot of money to reopen it, and so we're not going to reopen it. We'd rather spend the money on something else. We have our insurance premiums just like tripled, and we need the extra money for insurance, so we need to pull that from the budget somewhere, and that means the pool's not opening. Well, unfortunately, that is not something associations can do. And under this law, you're not allowed to just not open or allow access to a common element. You can only close it in these instances. So what do you do? What do you do if you have a hot tub that nobody uses, it doesn't work, nobody cares about it, and it's going to cost a lot of money to repair. What do you do given this statute? Because under the statute, you have to fix it and you have to open it. And it doesn't care, the statute doesn't care if you've got money to do that. So I would recommend to all boards, community managers, that if you've got situations like that, that you consult with that community's legal counsel to see if there is a way to remove that amenity completely from the community. So in other words, instead of keeping the hot tub closed, we remove the hot tub, we pave over it, we use that for something else, we use it as part of the pool deck or whatnot. So this is a legal analysis. I can't tell you, teaching this class, whether or not you can do it. It really is going to come down to your governing documents, what you see in the community's maps, and all of those things kind of combined together. You're going to need an attorney opinion on what you can and can't do with that particular amenity. Okay, but just keep in mind, we can't just close it off and say we can't afford the repairs or we don't want to make the repairs, therefore we're keeping it closed. Can't do that. That's a violation of Kiowa, violation of state law, and it does expose associations to liability if they get sued over this. Okay, let's do a few more. Pledging security for loans. Okay, so if any of you who are watching this have had the pleasure of working with your community to get a loan from a bank, you know that it is not a two-step process. And you know that the bank wants security for the loan. They're not just going to give you the money. In the old days, and by old days I mean like pre-2005, the bank said, we will take security interest to your common elements. And then they realized, as time went on, what the heck are we going to do with a greenbelt strip? What are we going to do? Sell it? Nobody's going to buy that. We can't get our money back that way. That's not good security for us. And so they changed. They changed what they were going to use as security. Moving forward, and currently, banks require a pledge of your future income as security. What is that? That is the right to collect assessments on the association's behalf. So if there is a default in the loan, the bank steps in and tells homeowners, you got to send your assessments to the bank now, and we will deal with this. And so the bank is essentially going to take the assessments and pay itself back. Not a great situation to be in for the association, because most bank loan agreements do not require the banks to then go and take care of the common area while they're, while they're getting these future assessments sent to them. And that's a problem, but you can breathe a sigh of relief. As long as I've been doing this, I've never ever seen an association actually default on a loan to the point where a bank stepped in and started collecting assessments. So that's a good thing. It's not something we see, but that is the security that is required. So long story short, I was just giving you some background there. Long story short, how do you pledge? Can you pledge your future income as security? Well, it depends. Under Kiowa, well, if you're pre-Kiowa, let's start there. The Nonprofit Act says you can pledge it even if that authority is not in your governing documents. Obviously, if your documents say you cannot pledge future income as security, you cannot do it. If your documents say you can do it with homeowner approval, then you have to get the homeowner approval. But under the Nonprofit Act, the default is you can do it even if your documents are silent. So pre-July 1, 1992 community, it's a lot easier. If you're a post-Kiowa community, in other words, you were created after July 1, 1992, you have to have authority in your declaration to be able to pledge the income stream as security. This provision, it kind of makes me laugh and cry at the same time. It's really stupidly drafted. Yes, I said stupidly drafted. I did because it is. Section 3021N of Kiowa says, it basically says, associations have the following powers and authorities, even if they are not specifically set forth in their governing documents. And it lists a whole bunch of different things, you know, like granting easements and imposing rules, you know, things like all sorts of things that we take for granted that associations can do. But when it gets to pledging your income stream as security, it says, associations can do any of the following without specific authority in their declarations, including pledging its income stream as security for a loan, comma, but only to the extent the declaration so provides. I don't know. I don't get it. It is like the most stupidly worded provision. Am I being too vague with how I feel about this? I'm not sure. Maybe I am. But so if you're a post-Kiowa community, you are stuck with this language that says you can only do it if, to the extent your declaration provides you can. So if your declaration is silent, you effectively cannot obtain a loan because you don't have the right to pledge that security, and a bank will not give you a loan unless you can pledge that security. So if you are desperate for a bank loan and you do not have that language or that authority in your declaration, I would recommend you work with your legal counsel to propose some sort of an amendment to your declaration, inserting that authority. Now, it can be with homeowner approval, it can be without homeowner approval, but you're going to need to amend the declaration to add that authority before you can go ahead and get a loan, unfortunately. Okay. Next, financial audits. They are required if two circumstances are present. The first one is you have annual revenues or expenditures of at least $250,000. And the statute goes on to say, as it is reported in your, your tax reports. So again, if you're bringing in $250,000 or more annually, or you're spending more than $250,000 annually, that's component number one. Component number two is a request from owners representing 1/3 or more of all units in the association. So both of these have to be present before the association is required to do a financial audit. Keep in mind, if your documents otherwise require a financial audit, like every year, every 2 years, you still have to comply with your governing documents. So you could have additional requirements in your deck. However, from a statutory perspective, this is the only time that Kiowa will require you to have a financial audit. So if a board wants to conduct a financial audit every year and their documents are silent, do they have to do it? Well, if they want to, they can, but they're not going to be required to do it unless both of these factors are present. So I'm not saying you shouldn't have financial audits if you don't have these two things. I'm just saying you're not required to do a financial audit if you don't have these two things present, or and your documents don't require it. All right, clear as mud, right? A few more things. Association can't vote, huh? Well, Kiowa says that any unit that is owned by the association is not entitled to cast any votes. This only applies to your post-Kiowa communities. And it essentially means if you got a unit through a foreclosure, or association went out and purchased one of the units in the community, it doesn't matter how you got it, you as an association do not get to cast a ballot on behalf of that unit. So if you are a pre-Kiowa community and you own a unit, you can still cast a vote, for that unit unless your governing documents prohibit it. Most older governing documents do not prohibit it, but you do need to make sure that your documents are silent on the matter before casting votes. Post-Kiowa, it doesn't matter what your documents say. Kiowa says, nope, can't do it. Cannot not insure common elements. You like my double negative? I'm very proud of that. So again, post-Kiowa communities only. Kiowa says, regardless of anything your declaration might provide, you have to insure all the common elements in the association. This includes limited common elements. Okay, so we're not just talking general common elements, we're talking the limited common elements as well. So let us say you have a community of condominiums, and each of the units has a balcony, which is a limited common element. And the declaration says, association must insure common elements, except that owners must insure their balconies. Guess what? That is a violation of Kiowa, and that's not going to be an enforceable requirement in the declaration. State law says, HOA, you have to insure the common elements, which would include the balconies in this particular case. And I know right now insurance is a very hot topic because folks are looking at ways to save costs. Premiums are outrageous. We're looking for ways that we can, lower those. And certainly, if we could require our homeowners to insure the balconies or their concrete patios or whatever else we could shift to them, that's great. That helps us as the association. But for a post-Kiowa community, you are locked into this requirement that as an HOA, you have to insure all the general common elements, all the limited common elements. Okay? So keep that in mind. It doesn't matter what your documents say. If you are a pre-Kiowa community, you insure whatever your documents say. So if your documents have a provision that says, owners, you must insure your limited common element balconies, that's great. Then owners have to insure it. However, post-Kiowa, you do not have that right. Okay, last but not least for Kiowa, failure to register with DORA. And maybe it's appropriate for me to take a couple of minutes here to just distinguish between registering with DORA and filing with the Secretary of State. Oftentimes, these two processes get confused with one another or are viewed to be one and the same. They're not. They're not at all. So Kiowa has a requirement that all associations register with DORA, okay, Department of Regulatory Agencies. This is an ongoing requirement. It has to be updated every year, okay? It is not the same thing as registering or updating your registration with a Secretary of State. The Secretary of State updates are not required by Kiowa. They are required by the Nonprofit Act, and they are a corporate requirement. They're not an HOA requirement, but a corporate requirement. So any corporation, any nonprofit, for-profit corporation has to file its reports with the Secretary of State every year. And that is completely separate from the requirement that you register with DORA. There's different information that is being asked in each one, and each one serves a different purpose. The Secretary of State report is to keep track of the corporate entity with the Secretary of State, which is what houses all the information with respect to the various legal entities in Colorado. The filing with DORA is specifically to keep track of HOAs in Colorado so that there can be information about HOAs. So we know how many HOAs exist. So we know the general parameters of HOAs. And that is something that was added to Kiowa. It's been quite a bit of time, but it wasn't there initially. So registering with DORA is a requirement of Kiowa. And the question then is, what if we don't register? Well, if you don't register, look at the 2 bullet points there. You are going to lose the right to enforce the lien for assessments. In other words, you don't get to collect assessments. And 2, you don't get to enforce your restrictions, at least not in court, because you have failed to register. So I don't know how to stress this enough. We have had situations where associations came to us and said, hey, we need you to file a collections lawsuit on this unit. And we get the file, we're looking through everything, we look on the DORA website, and lo and behold, your registration's expired. You're going to get a nice note from us or from any law firm saying, hey, we can't move forward with this. You don't have a right to enforce your lien or to collect your assessments at this point. You need to update your registration with DORA. Now, once you do that, you can keep moving forward. That's the good news. You're not like banned from ever enforcing this particular delinquency. You just can't do it while you're in violation of this requirement. In most cases, I think associations have either their management companies or their attorneys take care of it. So please just make sure you have a process in place for ensuring that the association, all your associations, get registered. Okay, I am done with Kiowa. So these all kind of like the little known provisions that kind of bite people in the booty when they don't comply. Let's look at the Nonprofit Act. I want to talk about demands for a special membership meeting. This happens a lot in our industry where you have homeowners submitting something to the association saying, we want a special meeting. Usually, what do owners typically want from these special meetings? Usually it's a meeting because they want to vote on removing a board member or the entire board. It's not always that, but I would say 80 to 90% of the time, that's been my experience, is that owners want meetings because they want to vote on board removal. Okay, well, this is something that the Nonprofit Act has very specific requirements for, although Kiowa is kind of peeking in there a little bit. First of all, one thing to be aware of is Kiowa does cap the owner request requirement to 20% of the units. Okay, so regardless of anything, and it doesn't matter when your community was created, regardless of anything that you have in your current bylaws or declaration that says, you know, a special meeting may be called on the request of 30% of the units. That's void. 20% is the limit, 20% is the cap. So don't reject a request for a special meeting if you don't get that number. As long as you have 20%, can't reject it. Okay, so keep that in mind. Once you receive that request from the homeowners with all the homeowners' signatures, you have 30 days as the association, you have 30 days to send out the meeting notice. In that 30 days, you should be reviewing all the signatures and making sure that the signatures are of actual owners, not tenants, not someone's roommates, not someone's spouse who's not on the deed. You want to make sure that the people who signed the request are actual owners in the community, and you want to make sure that it's at least 20% of all the units that are represented, right? So sometimes you'll see husband and wife, they're both on the deed, they both sign the request. Well, don't count that as 2 units if they're living in the same home, right? It's still only 1 unit. So you want to make sure that you truly have only at least 20% of units represented. Don't go looking at the signature saying, oh, this one's a forgery. I don't think this person actually signed it. Now, if you want to call the person and say, hey, did you actually sign this? You can. If they say, no, I did not, then I would ask them to please send an email, please send me something in writing indicating you did not sign this, and I will kind of cross this off as being a forgery. But don't just go crossing off signatures saying, well, I don't think Betty down the street would have signed this petition. Oh, she must have been tricked into signing this petition. I'm not going to count her signature. We can't do that. You should really only be looking at the signatures for identification of whether it's an owner and for counting. Okay. So at the end of that 30 days, assuming you have confirmed that at least 20% of the units are represented in the request, you should be sending out a notice of special meeting of members. It has to comply with all our notice requirements, which means it's going out 10 to 50 days before the meeting. Oftentimes, boards or managers will ask me, how far can I stretch this out? Well, I think the longest we can stretch it out is 80 days from when you get the request, because you have 30 days to actually send the notice. And then if you send it on the 30th day, you can send it up to 50 days in advance of the meeting. So you can do that, and then that adds up to 80 days. Most boards, however, say, let's just get it over with. We don't want to do the full 80 days. Let's just do it as soon as we can. So that's the board's option, but you can stretch it out up to 80 days. You certainly don't have to. So what happens if the association gets this notice and it does have 20% of the owners signing, or 20% of the units signing it, and we don't send anything out? We don't send a meeting notice out within 30 days. What happens? Nonprofit Act says that the owners who signed the petition or the request can call the meeting themselves, and they can run the meeting themselves, which is probably the last thing you want to see happen, because most likely what they're going to do isn't going to comply with the law unless they have an HOA attorney advising them. It's probably not going to be official, and then you're going to have to fight it as a board, and they're going to run it, and you're going to have no say in it, and it's just going to become a big old cluster, and it's not going to be good for anyone. So, word to the wise, you get one of these requests, please send the notice out within 30 days. If you determine that you did not have 20% of the owners or the units requesting it, then you still need to send something to whoever gave you the request, indicating that for these reasons, you have not complied with a 20% requirement. These signatures are not valid. These are tenants, not owners, whatever. But you still need to send something so they don't think you're just ignoring them and decide to call the meeting. All right, next. Requirement for changing quorum. This is quorum for homeowner meetings. Requires homeowner approval. In most cases, associations can amend the bylaws, most provisions in the bylaws, without owner approval. In most cases. This is an exception to that case. Even if your documents, even if your bylaws say you can amend anything in this document without owner approval, you're still going to need owner approval when it comes to changing quorum. No ifs, ands, or buts. If you are a post-Kiowa community, as a side note, you need owner approval to change other things in the bylaws, such as qualifications of directors. So we want to add a criteria to the bylaws that says board members must be owners in the association. Board members must be in good standing. If you're post-Kiowa, you're going to need owner approval to add that criteria. You're also going to need a homeowner approval to change the director terms. So we want to go from 2-year to 3-year terms. You're going to need homeowner approval. You are going to need homeowner approval if you are changing board powers. We're going to let the board amend, the articles all by itself. If you're trying to add powers to what the board can and cannot do, that's got to be approved by owners. And last but not least, you cannot add use restrictions, and that would normally be in the covenants. But a use restriction it's not exactly clear, but for example, if you're trying to regulate leasing in the community, if you're trying to regulate people smoking inside their units, those are generally accepted to be types of use restrictions. and you are not able to do that as a board, that is something that has to go to the homeowners for approval. That is a requirement. Okay. We are done with the Nonprofit Act, and we are moving on to the Condominium Act, last but not least, and then we'll get into the questions. Most of the Condominium Act is completely overridden by Kiowa and doesn't even apply anymore. It's a very short statute, but it does still have one provision that applies to pre-Kiowa communities, only pre-Kiowa communities. And that provision says at least 1/3 of the terms of the board must expire annually. And this is only for condominiums. Remember, this is the Condominium Act. Doesn't apply to any other type of community, just condominiums. But if you have a community, a condo community created before July 1, 1992, you do still have to comply with this requirement. At least 1/3 of the terms of the board must expire annually. So what does that mean? Well, it means if you have a 5-member board, what is 1/3 of 5? Well, 2 is over 1/3. So you're going to need either 2-year terms or 4-year terms. Well, actually, you're going to need 2-year terms because you're going to have 3 terms expire 1 year and 2 terms expire the following year. That's the only way we can comply with the 1/3, right? So it gets a little complicated in trying to figure out the director terms and how to set that up and things like that. And so a lot of condominium communities that are older don't even realize this requirement exists, and they have no clue that they're not complying with it. So I would tell you, if you are managing one of these communities or you're on the board for one of these communities, keep this in mind. And if right now you're operating with a board where you do not have 1/3 of the terms expiring annually, at least 1/3, you are in violation of the law and you need to consult with your legal counsel to figure out how to fix it. Okay? All right. I will give you a comic moment. Mostly because I like the little chihuahua because he's so cute. But, all right. Dun, dun, dun. Let's go on. Let's go do the questions here. I'm going to start at the beginning. Oops. Okay. Does the disclosure have to go out on an annual basis then? Yes. Does the notice for what the website addresses have to go out annually? So this is all for the disclosure piece. Yes. The answer is yes to both. Sorry, I'm trying to. Next, let's see. Does the notice for what the website is have to go out? Oh, sorry, it's the same question. Yes, it does have to go out annually. Does the association also have to post board member contact information, name, mailing address, units, and email addresses? Does the association have to post this? No, that's not one of the requirements for disclosure, but it is a requirement for information that must be made available to owners if they ask you. So you need, if someone asks, you got to have the name of the board members. You have to have an email address for the board members, and really that's, and their, you don't have to do the address though. So, but you have to have their names and their email addresses in there, okay? If we are a pre-Kiowa community, and our declarations allow us to limit common elements like the pool, if someone is past due, can we continue with that practice? That's a great question. Yes, you can. So the statute that talks about you can't cut off access to common elements except for when you're repairing, that does not apply to situations where you are in the process of enforcing your documents. based on a provision that says as part of the enforcement, we can, cut off your access to the pool or the common elements. So that's punitive. What it says is you really can't cut off access to the entire community for no good reason. Okay. So yes, you can still do that. Are audits required annually? They're only required annually if your documents require it annually, or if you annually get the request from 1/3 of your owners and you annually spend or bring in $250,000. Otherwise, there's nothing in state law that requires them annually. For signatures on a request for a special meeting, is it valid if someone is the power of attorney for the unit owner? If they have a power of attorney that specifically allows them to execute HOA documents on that person's behalf, we have to accept it, but then they should be attaching a copy of the power of attorney. We have no way of knowing that they truly have a power of attorney. You don't have to take their word for it. They need to be attaching a copy of it. And then I would say accept it. Okay. Are there any requirements that bylaws must be updated on some sort of interval to ensure they are in compliance with current laws? Another good question. The answer is happily no. There is no requirement like that. Some states actually have that requirement. For example, in California, attorneys get to make a lot of money because when the law changes, associations are required to update their documents accordingly. And so they have to go through that process. In Colorado, we do not have that requirement as of yet. I have not heard of that coming up as a requirement in any pending legislation or even talked about legislation. So for now, we don't have to update our documents just because the law has changed. However, you probably want to make some sort of even a handwritten notation in your documents so that you're not trying to enforce or do something that you can't legally do anymore. Are owners entitled to receive financial statements regularly? So again, you're posting the financial statements as part of the disclosure, so they have those. If they want more recent financial disclosures or they want like prior financial disclosures, they have to go through your request and inspection of records policy, which has a process set forth in there for how they are supposed to do that. So they are going to have to follow the policy to request that. You don't unilaterally have to send copies to owners on a monthly basis of the statements. They must be requesting those. Post-Kiowa association with the owners that cannot vote, does that imply indefinitely? Does that mean that the only people who can vote are the ones that purchased a home from another person directly? Not necessarily. Any owner can vote except for the association. So in other words, the association has to be on the title, not a board member of the association, but the actual association. And that really doesn't happen very often where we see an association as the owner. It happens the most, it happens usually through foreclosures, but even that doesn't happen very often. So the association as the corporation would have to be the owner for it not to be able to vote on behalf of that unit. We're not talking about units that are owned by like board members. So hopefully that answers your question. Oh my God, you're not going to believe this, but I think that was the last question. Let me just do one final. Yeah, that's the last question I see. Thank you for joining me. We get out a few minutes early. Good for us. If you have any questions that you think of, here's my email address up on the screen. Feel free to send me an email. I try to respond in a timely manner to these types of questions about the webinars. If you're a client, a lot of times we have to look at your documents, and then there's a charge. So just be careful and be mindful of, the types of questions that you're asking, or you can ask if there's a charge to respond. Anyway, thank you for joining me. Please, if you have time to fill out the survey, please do that. Thank you. We'll see you next month, everyone.